Are you waiting for your client, Attorney Webster Cox?
He's in custody.
Okay. All right, it shouldn't be long. I'm gonna handle a waiver and a address bond, and hopefully they'll be logged on at that point.
Okay, because I don't know if you know, but we're asking for a referral for competency and criminal responsibility. And APA Penny is here as well. I think he's on the same page, or he should be aware of it.
I'm aware. Darnell, let me know.
Great. Thank you.
Okay, thank you for letting me know. Okay, let's handle Mr. Weber first.
The state of Michigan City, Detroit, 36 District Court is now in session. Your Honor, with Judge Aliyah Sabree presiding. Good morning, Your Honor.
Good morning, everyone. Okay, we're on the record. This is people of the state of Michigan versus Jerome James Weber, case 2159876. Mr. Weber is charged with 1 count of weapons carrying concealed, set for a PCC this morning. Appearances?
Good morning, I'm Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor. Steve Mencken, P31562, appearing on behalf of Jerome Weber.
Mr. Weber, can you unmute your device and state your full name, please?
Hit *6.
Can you hear me now?
I sure can. State your name, sir.
Yes, my name is Jerome James Weber, Your Honor.
Thank you. Good morning.
Good morning, Your Honor.
Okay, Attorney Mencken, is it correct that your client is wishing to waive his exam today?
That's correct, Your Honor.
Okay, is there an objection from the people?
No objections, Your Honor.
Mr. Weber, I'm going to ask you a series of questions. If you do not understand my questions, or if you cannot hear me, please let me know and I'll repeat the question, okay?
Yes, ma'am.
Okay, is it your wish to waive your preliminary exam today?
Yes,
You understand you have a right to a preliminary exam?
yes,
And that if you were to demand that exam today, the people, the prosecutor would have to show at the probable cause standard, which is a much lower standard in criminal law, but still a standard, that the one charge I just read off, carrying a concealed weapon, was committed in the city of Detroit, and that you probably committed that crime. Do you understand that?
yes,
And that by waiving your exam today, the people do not have to prove anything at the probable cause standard. You understand that?
yes.
And I'm letting you see a little, I want to make sure you understand, you're not giving up your right to trial. You understand that as well?
Okay, I was just thinking that too.
Yeah, I can tell by your facial expression. You're not giving up your right to trial. This is just a preliminary exam stage, the probable
Okay.
cause stage.
Yes,
So knowing this information, do you still wish to waive?
yes,
Okay, did anyone force you or threaten you to waive your preliminary exam?
no,
Did anyone promise you anything for you to waive your exam?
no.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to 3rd Circuit Court, Frank Murphy Hall of Justice, 2 weeks from today. That'll be April 5th at 9:00 a.m.
Okay,
And also, Mr. Weber and Attorney Mencken, do I have your permission to sign your names on the waiver form?
Yes, Your
no,
Honor. No, yes, Mr. Weber, it's just, you've already put it on the record. It's just putting it in writing what we just did. And I'm gonna agree that the judge can sign my name and he can, and she'll sign your name. So I don't have to get you the actual copy.
oh,
It's just
Okay.
a form that says we waive the exam. That's it. And it's.
okay.
constitutionally bound.
And y'all, I still got another court date coming up.
Yeah.
Okay, well, just to be clear, I'm signing your name, it'll say with permission from Mr. Weber. It's just paperwork that has to be sent over to 3rd Circuit.
Okay,
And as far as your other court date, I believe Attorney Mencken, you could talk to them about that.
yes.
Okay, anything else on the record?
No, Your Honor. Thank you.
Go have a good day.
You too.
You too.
Give me one moment. Weber, I'm gonna log you off now, okay? You're all set.
Okay, thank you.
You're welcome. Attorney Belcher, good morning. I see you.
Good morning, Your Honor.
You're here to address bond?
Yes,
Okay, give me one moment. I want to see who this is in custody here, okay?
yes, ma'am.
To the gentleman in the Wayne County Jail Division 2, can you state your name, please?
Andre Hardaway.
Okay, everybody ready on Hardaway?
Ready?
Yes, Judge, thank you.
Okay. This is case 2355951, the people of the state of Michigan versus Andre Neal Hardaway. Mr. Hardaway is charged with count 1, assault with intent to murder, as well as counts 2 and 3, assault with intent to murder. Count 4, weapons, firearms, possession by a felon. Count 5, weapons, felony firearms, second offense notice. Counts 6 and 7, weapons, felony firearms, second offense, as well as count 8, with the habitual offender fourth offense notice set for a probable cause conference. Today appearances.
Good morning, Your Honor. Matthew Penny, P74079 for the people.
And good morning, may it please this honorable court, Dion Webster Cox, P70422, and I'm co-counsel for Mr. Hardaway.
Mr. Hardaway, can you please state your full name for the record?
Andre Neal Hardaway.
Thank you. Good morning.
Good morning. Your Honor, at this time, we are requesting a referral for criminal responsibility and for competency.
Okay. And at the rate right now where the forensic side, how the forensic center is working, I can't give an estimate. It's taking a very long time for these reports to come back. So do you all want to do 60 days or 90 days?
Let's do 90.
Yeah, I think 90 makes sense. My last one was about 4 months, and that was just a few weeks ago.
Okay. How about June 20th, 9 o'clock?
That'll be fine.
Okay, June 20th at 9 o'clock.
Yes, that's pretty far out, so if we get closer to the date and it needs to be changed around that time, of course, just let me know.
Perfect. Thank you very much. Have a great day.
You as well. Anything else for the record, Attorney Finney?
No, not for the record. Thanks so much, Judge. Have a nice day, everybody.
You
You
too.
as well.
And Mr. Hardaway, I'll come see you. Okay? Thank you.
Thank
You're all
you.
set, Mr. Hardaway.
Thank you.
Have a good rest of your day. Okay, to Mrs. Hill now. This is case 230559006, people of the state of Michigan versus Shatonda Hill. Ms. Hill is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, assault or assault and battery. Set, it's actually not set on the docket, but here today with Attorney Belcher to request adjusting the bond condition, is that correct?
Yes, Your Honor, that is correct.
Okay, appearances?
Good morning, Your Honor. Daniela Parrish on behalf of people, P85495.
And good morning, Your Honor. May it please the court, Leanna Belcher, P80177, on behalf of Ms. Hill. Your Honor, I would ask to waive her appearance for today's hearing.
Okay, that's fine.
Thank you, Your Honor. And this matter was before you yesterday for probable cause conference. We did set a preliminary examination date for August 11th. I did bring up a possible issue with bond. The complainant in this case is residing in the same house as Ms. Hill. It is her boyfriend's brother. They are family. At that point, Your Honor said that we could always send an email if the APA handling the matter yesterday was able to confirm with the complainant that he was okay with my client returning to the house. I did receive an email response yesterday towards the end of the day from Mr. Kirker stating that he did make contact with the complainant, that he was a little confused about the situation, but said he would be okay with her returning home as long as she did not bother him. Your Honor, the reason I believe we were not able to just send an email to the court was that Mr. Kirker did not feel comfortable consenting without approval from his supervisors. So I thought it would be more efficient to bring this matter in front of your honor. My client is paying for a hotel room every night. She is indigent. She is running out of funds, your honor, and this is becoming a situation that's creating a financial hardship for her. I would ask, given the representations made to the prosecutor from the complainant and the ones that I made to the court, that your honor modify the bond to allow her to return home and have no assaultive contact with the complainant. Ms. Hill has assured me that she will be staying on a separate floor of the house, that she's purchased a mini refrigerator so that she can limit her contact down in the areas where they would run into one another until this case is resolved. She just simply does not have the money to pay for any more hotel rooms.
And Mr. Kirker is here today. I'll say from the people, you all have anything?
I do. Daniela Parrish on behalf of People P85495. I object to this request of this bond reduction or adjustment in this case. It's a felonious assault. Having these three people, obviously the victim is related to the assailants, the defendants, boyfriend, their brothers. There should be no contact in this case, not just no assaultive contact, because there's a lot of influential things that can occur, especially under the same roof. And having them live under the same roof is absurd, in my opinion. So I understand that it may be costly. Maybe she can reside with a friend or a relative. Maybe she should have thought about this before this incident occurred. Nonetheless, I understand she is not convicted yet, but we have to have the ability to hold the preliminary exam, possibly the trial, without these people having contact. So even though I do understand the situation, it may be a financial burden, but that is not of our concern. As of right now, our concern is having this case go forward without the victim being influenced. And as APA Kirker indicated, the victim seemed confused while talking to him anyways, and then eventually was like, well, I don't have, obviously he's not gonna have a problem because his brother is now influencing this, and we have his brother's girlfriend. It's a dynamic that I think is.
Can you just clarify what the complainant stated when asked?
Well, he initially was confused, according to APA Kirker. But we, as APA Kirker indicated, we don't have the ability to influence a victim to agree to allow contact. And yes, APA Kirker did reach out to him to feel it out. In his opinion, even regardless of what the victim indicated, that at the end that he wouldn't have an issue, the people have an issue. But again, more so with the fact that it took a moment to get to that. There was a lot of confusion as to what was being asked of him and whatnot. I just think that for keeping matters where nobody is influenced in this case, regardless if it's the defendant doing the influencing, the defendant's third party, the boyfriend that is the victim's brother. It's just it's a domestic situation that should be avoided at all costs. So unfortunately for the defendant, she's the defendant in this case, so we can't ask the victim to leave his home. But as of right now, residing together would be inappropriate. Obviously, it's up to the judge, but we feel that people will have to decide.
Clarification, Mr. Kirker, maybe you can provide, since you spoke to the complainant witness. Did you?
Yes, let's talk to the complainant.
What was the conversation?
He didn't seem aware of this conversation about allowing the defendant back into the home. So I have to explain the situation to him. And he kind of wavered, went back and forth, and then eventually said possibly okay to it. But
And that is why I said I feel that it was inappropriate, because now it's almost as though we the people are almost influenced. don't want that, so I'm going on record objecting to any adjustment at this time.
Attorney Belcher, you were responding.
Yeah, Your Honor, and I apologize. There's a lot of feedback from the courtroom, so I couldn't hear everything that Mr. Kirker was saying. But the email that I got from Mr. Kirker stated that he was confused at first, and part of that could be because these are individuals that have had no contact with the criminal justice system. So I'm sure they don't understand the procedure. I know I've had to explain that to Ms. Hill several times. But at the end of the day, these are people that reside in the same home. This is Ms. Hill's house. Her name is on the paperwork for the mortgage and for the deed. The complainant is not. He resides in a different level of the house. And from Mr. Kirker's email to me, he is okay with her returning home as long as she does not bother him. She has absolutely no intentions of bothering him. This case will play out. There has been no allegations put forth that she's tried to persuade or have influence. So that's completely inaccurate, or she would have been brought before Your Honor for bond violation. These are individuals that are in an unfortunate situation, but Ms. Hill is presumed innocent. We will see how this case moves forward. Ms. Hill has every intention of being cooperative. She has no criminal history as far as I could see from any prior felony cases pending in the 36th District Court or any charges that I could find. This is simply a situation that these individuals are going to end up living back together at the conclusion of this case anyways. And the complainant himself is okay with her coming back to the house.
That's not what my understanding is based off of Mr. Kirker, who spoke directly to the complainant witness. That's why I had Mr. Kirker speak, because he said that he seemed confused and wavered back and forth. The request to me is already bizarre to allow someone who's been charged with assaulting someone, feloniously assaulting someone, to come back into the house that the person lives in. If I was a complaining witness and the prosecutor called me, I would be confused as well, because I would think that the prosecutor's job is to protect me, not to bring the person who I alleged or said hit me or assault me to bring it to my house or the house that I'm living in. I think the recourse at this point, if you're saying this house is Mrs. Hill's house and the complaining witness has no rights to live there, then Ms. Hill can move in that direction to occupy her home, as well as if the complaining witness is so willingly allowing this person to stay, and that at the end of this, they're gonna all live together and everything. I'm not understanding why these charges have been brought before the court. I'm not sure how and I don't know the details, so I'm going to leave that alone, but it doesn't make sense to me that the complaining witness would be okay with someone coming back into the house that assaulted them, allegedly assaulted them, and still want to push forward with the case. So I am of the belief that I want to continue to protect the complaining witness until there's some testimony that's provided to show otherwise. I think it would be a complete disregard and failure on the court's part to allow the defendant to go and live in the same place as the person who has said they've been assaulted and allow for that to happen or anything else happen. It would be completely it would be my fault. So I don't feel comfortable with it. Ms. Hill, that's her house. She has every right to occupy it, and she can, if there's no lease, and if that person, the complainant witness, is not on the deed, then she can move forward with having that person removed with the help of court officers or legal, not doing it herself. But at this time, I'm not going to adjust bond to allow her to go back to that house while the complainant witness is there.
Understood, Your Honor. I will let her know. I will advise her to start eviction proceedings, and I apologize for wasting the court's time this morning. And the email from Mr. Kirker never mentioned that the complainant went back and forth. It just said that he felt confused, and my interpretation of that was he just didn't understand the legal process. And then he said he was okay with it as long as there was no contact.
Ms. Belcher, I don't think you're not wasting the court's time, just to be clear. I don't think you should waste the court's time at all. But I had to hear from both sides what was going on.
Understood, Your Honor. I will let Ms. Hill know that this point that she's going to have to figure out other living arrangements until the complainant can be evicted.
Okay, and I'm going to let you're with NDS, correct?
No, Your Honor, I'm not.
Oh, you're not. Okay, I don't know why I thought you were.
Everybody
Okay.
thinks that, and I don't know either.
I don't know why. So, okay, well, I can't give legal advice, but, the eviction process is taking a while, but there's an option for emergency evictions based off of certain circumstances.
Yes, Your Honor, I will advise her to consult with an attorney regarding that issue.
Okay,
Thank you.
all right. You're welcome. You have a good day. Or you have a good day.
You as well.
I thought she would be. Attorney Martin, good morning.
Good morning, Judge. How are you?
I'm fine. How are you doing?
I'm doing pretty well.
What's going on?
Judge, my client Donald Johnson, his case is before your court. Right now, it's pending a competency and criminal responsibility evaluation. However, I'm contacting you concerning his bond. He is on tether with house arrest at a rehabilitation facility where he's living, and everything is going really well there. However, he's been doing some job seeking online and he has a couple interviews. And so he needs his bond modified so that his tether agent will allow him to go to those job interviews.
Okay, can you provide that information to the tether unit where the interviews are going to be?
I'm sorry, can you repeat that, Judge?
Is he able to provide information as to where those interviews are?
Yes. He has
Okay.
one at Chili's in Southfield on March 30th and one at Applebee's in Southfield on March 24th.
Okay, any objection from the people for allowing Mr. Johnson to go to job interviews? I'll give you the charges here. I guess I should, let me read the case off first. Okay, case 2106238, people of the state of Michigan versus Donald Eldridge Johnson, charged with count 1, weapon, firearms, possession by a felon. Counts 2 and 3, assault with a dangerous weapon, felonious assault. Count 4, 5, police officer assaulting, resisting, and obstructing. And count 6, 7, 8, and 9, and 10, weapons, felony, firearm. Appearances?
Alexander Kirk on behalf of the people, PA 6282.
Alicia Martin, Your Honor, P69003 on behalf of Mr. Johnson.
And Attorney Martin, before I call the case, you're requesting to adjust his bond conditions so that he is allowed to go to job interviews from his treatment center, correct?
That's correct, Your Honor.
Okay, now, Mr. Kirker, do you have any stance on this request?
I do not have an objection to this request.
Okay, so I'm just going to ask that Attorney Martin, your client provide to the tether unit as he is getting job interviews, the date, the time. I'm gonna put on the reduction form or the adjustment form here that he is allowed to go to job interviews as long as he provides that information to the tether unit.
Thank you so much, Your Honor.
You're welcome. Anything else?
No, thank you.
Have a good day.
You too.
And Attorney Zarani, good morning.
Morning, Judge. How are you?
I'm fine. Doing. We don't have any other, let's see. You know what? Let me see if we can see what's going on, because I don't see, he might be in person by now. I just thought about that.
Oh,
Because he's scheduled for an exam. Let me see if he's downstairs. If not, then we'll have to look at.
okay.
Give me one moment.
Thanks, Judge.
Mhm.
That is matter of protocol. You don't allow the defendant
Alright, so that's that. No, no, you do. Like you need more time. Cause you got too much. Figure it out. Not me, though. Check it out for anything. You see my answer to that? This right here. sure. We have Mr. A.G. in the courtroom.
Ready, Your Honor.
Okay. You need to, well, it'll be difficult, but do you need to speak to them before we go on the record?
No, we're all set, Judge. Thank you.
All right, we are on the record. The people of the state of Michigan versus Nicholas A.G., who is defendant number 3 on case 2355480, and charged with 1 count of police officer assaulting, resisting, and or obstructing with the habitual offender's second offense notice set for a preliminary examination this afternoon. Appearances?
Alexander Kirker on behalf of the people, P86282.
Bob Zaranick for Mr. A.G., Your Honor. Please state your name, sir.
Nicholas A.G.
Judge, I did explain to Mr. A.G. his right to an exam. He wishes to waive that right at this time, be bound over to circuit court for further proceedings.
Okay, Mr. A.G., I'm going to ask you a series of questions. If you don't understand the questions, or if you can't hear me, just let me know and I will explain further or repeat the question, okay? And make sure you speak up for your answers so the court reporter can hear, all right? Okay, is it your wish to waive your preliminary exam today?
Yes, ma'am.
You understand you have a right to an exam?
Yes, ma'am.
Okay, and that if you were to demand that exam today, the prosecutors would have to show at the probable cause standard, which is a much lower standard in criminal law, but still a standard, that the 1 charge I read off was committed in the city of Detroit and that you probably committed that crime. You understand that?
Yes, ma'am.
And that by waiving your exam today, that means that the people do not have to show any test, prove anything today or provide any testimony or evidence. Do you understand that?
Yes, ma'am.
And you also understand you're not giving up your right to trial, right?
Yes, ma'am.
Okay, and knowing that information, do you still wish to waive your exam?
Yes, ma'am.
Did anyone force you or threaten you to waive
No,
your exam?
ma'am.
All right, did anyone promise you anything?
No, ma'am.
Okay, I find your waiver to be freely, understandably, and voluntarily given. Since you're in custody, I will have you bound over, and your arraignment on the information at Frank Murphy Hall of Justice will be 1 week from today, April 29th at 9:05 a.m. Okay. Anything else?
That would be March.
I'm sorry, March. I'm trying to get out of March.
April.
I like to move to April, but we are still in March. I'm sorry. Thank you. So March 29th at 9:05 a.m. I started confusion on your right. Thank you, Ms. Franklin. Anything else for the record?
No, thank you, Your Honor.
Thank you. You have a good rest of your day.
You too, Judge. Thanks for that picture. That was great.
Well, thank you.
See you later. Take care.
Bye. Attorney Choate?
Good morning.
How are you today?
I'm good. How are you doing?
Pretty good. You have Mr. Tolbert?
I do, yes.
Okay. All right, he's not here. Have you been in contact with him yet?
So I have contacted the number that was listed and spoken with his mother. His mother did say that he was in custody. I've not yet been able to locate him at the jail. So that's why I was hoping he had been zoomed in today.
So he is on tether according to this update.
So if I could get an adjournment, Your Honor, to attempt and locate Mr. Tolbert. I was looking at the report just now and it looks like I saw that he had a tether, but he had a cash bond as well that I didn't know if that was what was holding him.
Okay, I just need to check the arraignment date. You call Attorney Lamb. Just call.
Are you all putting out
It's one here, sir. Mr. Epps. This needs a signature. Yes. Thank you.
Okay. How about next Wednesday? Does that work?
We'll check here. That should be perfect, Your Honor.
Okay, let's do 8:45.
Thank you so much, Your Honor.
You are welcome. I want to, can I set a date for April 12th for the exam? And then it can be removed, but I just need to set it within a certain time frame.
April 12th, you had said?
Yes.
Yes, that should be perfect. It looks like I have something in the Third Circuit at 9 o'clock. If you have anything in the afternoon.
Let's see. Yeah, 30 on April 12th.
That would be perfect. Thank you, Your Honor.
Thank you. I will see you next week.
You too. Hopefully you have a good rest of the week and weekend.
Thank you. Okay, we're on the record, this is case 225757, people of State of Michigan versus Nathaniel Allen Jenkins. Mr. Jenkins is charged with count one, controlled substance delivery, manufacture of cocaine, heroin, or another narcotic less than 50 grams. Second, for subsequent offense notice. Count two, controlled substance delivery, manufacture of cocaine, heroin, or another narcotic less than 50 grams. Second, for subsequent offense notice. Count three, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. Count four, weapons and munition possession by a felon with individual figure four has notice set for further examination.
Alexander Kirker on behalf of the people, P8628.
Ma'am, please, I'm a court race age for the defendant. Something about, 41, 18, or 18, today we make such examination. Here, I would ask for some clarification on the issue.
Sir, you said your name.
Nathaniel Allen Jenkins.
Anyone is watching on YouTube or Zoom who may be a witness on this case, now is your time to log off. For the record, there's no one else in the courtroom other than lawyers, staff, and Mr. Jenkins. Are there any other preliminary matters?
Your Honor, if you occurred, and this case is under the law.
Officer Epps. Attorney Tiapo, good morning.
Yes, good morning.
Okay, we only have one more matter today, this morning.
Yeah.
It's my understanding that you have not been able to contact your client.
That's correct, yes.
Okay, let me call the case. This is case 2256676, the people of the state of Michigan versus Cameron Carter Greenlaw. Mr. Greenlaw is charged with one possession of methamphetamine and or ecstasy set for a probable cause conference this morning appearances. Good morning, Your Honor. Danielle Parrish on behalf of
Rebecca Tiapo, P62311, on behalf of Cameron Carter Greenlaw. And I attempted to reach my client through various methods. I've not received any response back.
Okay. Let's see, where he does have a KPS history, he did KPS on September 23rd, 22 for a probable cause conference. And the judge, I'm not sure who it was, Amber Jones stated that the president or the defendant must be present at the next Zoom hearing on March 16th. He was not present. I waived his presence. And today he is not here. So I'm going to issue a KPS. It will be $1,000 cash or surety. And we'll go from there.
And the March 29th exam will be canceled, correct, Your Honor?
Yes, it will have to be because today's 22nd. By the time he gets the range, he will have to have 7 to 14. Yeah, it'll be canceled. So we'll have to start over.
Thank you so much, Your Honor.
Thank you. You have a good rest of your day.
Right.
Back on the record for Nathaniel Jenkins, appearances.
Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
Mayor, please on report, Your Honor, I know it's great case, I think number 41848. Today is date set for examination. And I came here to do an examination. However, in talking to court appointed counsel, there's something that's came to my attention that I didn't know about. And was not provided in the defendant's discovery. Based on that information, I'm going to ask for adjournment to allow me to go over this information with my client. Yeah, I've been doing this for 35 years. I know how to do a probable cause examination, and I've been pretty good at it over the years, if I have to say so myself. And so today I came here prepared for one particular strategy. Something just was raised to elevation that I think is the best interest of justice. I have occasion to go over it with my client before we conduct the examination.
Did you have discovery? Did you have discovery before the hearing?
I had reviewed some discovery from the defendant, but I was familiar with the case and had investigated with the defendant, and I knew what I wanted to get out of this examination this morning. So I knew what I was doing this morning.
So how were you made aware of this case? That's right.
I was retained about a year ago. I mean, by the defendant when they first was investigating this case, and I was in contact, I think, with the officer in charge of people. They had not charged him, and I was involved in it over a year ago.
Did you ever file an appearance?
There was not a case, there was not a case back then, and no case to file an appearance
What I'm
on.
asking, when he was arraigned, how were you made aware of this case?
When he called me and told me that, he had been arraigned and that he had had a couple pre-trials.
Okay, because I'm trying to understand how you show up today, but you were never provided discovery from the prosecutor because we don't have an appearance, or we didn't know that you were the attorney, and then asking for an adjournment because we found out about information from the attorney who has been on the case and prepared, and discovery that you're learning of today, but you never requested discovery from the people.
No, I didn't.
Known about.
Right. But the part that I'm dealing with is just is a sub issue. You know, it's not about the substance of the case. It's just something I just need to go with my client. If you're not going to allow me to have the adjournment, you know, I think that is manifest necessity that I have occasion to discuss substantive issues with my client. But I'm prepared to go forward. If you don't want to adjourn this,
I don't want to adjourn it, and I'm not sure I understand. You're not giving me any information as to what it is.
I can't. I share some privileged information here, but I'm prepared to go. Let's go. I mean, this is going to be a tumultuous examination because the subject matter is going to be a little bit heated, but I'm prepared to go.
Okay. Let's go.
Your Honor, I myself was a little confused. I didn't know if it was something that needed to be discussed and whether your defendant wanted to actually go forward with the exam. That being said, I don't mind to wait a few minutes. I know that's not giving him a lot, but if he needs to speak to, defendant for a few minutes to get the ducks in a row, obviously I want the defendant to feel that they are accurately and effectively represented today, if he does not want to waive the exam after discussing whatever this new information
We're not
is.
going to wait for the examination.
Okay.
but
Because we
can go
have
forward.
our officers here,
All right.
we'll try to keep it as, Your Honor, I'm gonna try to keep it as simple and straightforward as possible.
Look through how you're going to strategize. I need today's date for the exam, and unless there's an issue articulated, I'm ready to hear testimony. Any other preliminary matters?
Yes, Your Honor, people have multiple, post exhibits, as preliminary matters, I just shown defense counsel. Under MCL 766.1118, people move to admit people's proposed exhibit 1, the state police forensic lab report, which states basically that the recovered container 1 was recovered, was identified as cocaine and tested positive for cocaine, as well as container number 2 that was a heat sealed plastic container that contained 61 folded paper packets, was tested positive for fentanyl. Also under MCL 766.1118, people move to admit people's proposed exhibit 2, the MSP lab report, which states that we recovered 21 white brown tablets that were in a non-clear plastic bag, tested positive for oxycodone. Finally, proposed exhibit 3, which is personally admissible under MCL 766.11B, a certified copy of the register of actions, which states the defendant's previous felony conviction of unarmed robbery with conviction or sentencing date of August 15th, 2017, out of Third Circuit Court here in Wayne County.
Has the defense counsel had an opportunity to review those documents?
I'm sorry, Your Honor?
Has Attorney Page had an opportunity to review those documents?
Yes, I showed them to him prior to the preliminary.
Any objection?
And foundation wise, I'm objecting because there's not been a foundation.
I mean, hold
There's not been a foundation to allow that kind of evidence in, even by stipulation, until she lays a proper foundation.
So under 766.11, says the rules of evidence apply to the preliminary examination, except that the following are not excluded by the rule against hearsay shall be admissible in the preliminary examination without requiring testimony of the author of the report, keeper of the records, or any additional foundation for authentication. So with that, I want to allow the interest of those exhibits over the objection that's been noted on the record.
Thank you, Your Honor.
Any other preliminary matters?
No further preliminary matters from people, Your Honor.
Any from defendants?
No, ma'am.
Okay, go ahead first, please.
Thank you, Your Honor. Calling first witness, Officer David Casper.
First, then I'll. Thank you. Okay, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. The door's right in front. And make sure you speak up. Whenever you're ready, Ms. Perry.
Officer, I'm going to ask you a set of questions, serious questions, and then afterwards, defense will cross-examine you. I have a little hard of hearing, and I also want the court reporter to hear everything, so you can speak into the mic while answering the questions, and then mic move, so you're free to put it in your lap, whatever is easiest for you. Would you mind, please, restate your name for the record, please?
That's the Detective Trooper, David Tasker.
Trooper Tasker, could you please tell us where you're currently employed?
I'm Michigan State Police.
In what capacity?
I'm currently assigned to the Metro Narcotics Enforcement Team.
Have you had specialized training in conjunction with that specialized unit?
Yes.
What type of specialized training?
I've been to various narcotics trainings, along with undercover narcotics school, surveillance school.
Trooper, how long have you been a police officer?
7 years. I've been a part of the narcotics unit group too.
Were you employed in this capacity on February 22nd, 2022, sir?
Yes.
You know what, and I apologize. February 2nd, I don't know if I said this, February 2nd, 2022?
Yes.
You recall if you were working by yourself or with partners that day?
It was our full team.
Were you in uniform on that day, sir?
Yes.
Was it a full modified uniform?
It's a slightly modified uniform, but it still has state police markings.
Can you describe what that means, or what modified uniform looks like?
It's not the typical like road trooper uniform you would see, like the blue uniform. It's like a fatigue uniform.
Does it indicate police or anything of that nature?
Yeah, that's state police on it.
Does it come, does your uniform come equipped with body worn camera? Were you in staff car on that day, sir?
No.
Did your duties as a Michigan State narcotics police officer take you at near 2683 Central Avenue, apartment 8, the city of Detroit, county of Wayne, sir?
Yes,
Can you please tell us why you're at this location?
we are there to execute a narcotic search warrant.
Where were you, are you aware of why you were conducting a narcotic search warrant on this particular location?
It was we were there because the overdose caused death.
Objection to hearsay, Your Honor.
I'm asking him if he knows why he was there. I don't believe that that's hearsay, why he was there.
Well, if he doesn't have direct knowledge, it's based on something somebody else told him, it's hearsay. And she hadn't laid a proper foundation that he would know personally, other than based on hearsay. And I object to it and note it for the record.
I didn't, you didn't give a response yet as to how
I would ask for him not to take a response because unless you had some proper foundation, you know, whatever comes out of his mouth is based on hearsay.
So how was the officer get called?
I don't know. She had to, that's her job to get it to the court. I don't know.
Are you aware who resides at this location, sir?
Yes.
Did you make contact with the person that resides at this location prior to the search warrant?
Yes.
You know, again,
Ask for a foundation.
I object to offer of proof that he resided at that residence.
You haven't even
You haven't
gotten
got
to
to
who that
that
person is. The defendant, your client hasn't even been indicated yet.
He just said Nathaniel Jenkins. That's what he just said. Did you say that?
Yes.
That he was executing a search warrant.
Right. For Nathaniel Jenkins, and he did not laid a foundation that he lived at that residence.
Okay, I will happily ask this is why I'm asking these additional questions. Asking if he had contact with the person prior to the search warrant to lay this foundation. Not that it's necessary for us to lay a foundation for the search warrant, but because he wants to know, since I asked why they were there, I'm happy to do so.
So you overrule my objection?
So your first objection was based off of hearsay.
Right.
And I didn't even hear a response to say whether or not it was hearsay. So then I had the prosecutor lay a foundation. I can't rule on the hearsay, nothing she said. For the answer of what she was going to say. So she finally laid a foundation as to why he was brought to the location. So I went over.
Officer, did you have contact with the suspect that resides in this location as you indicated prior to doing the search warrant?
Yes.
Could you identify the person that you had contact with prior to?
Yes.
Is that person in the courtroom today? If so, could you please tell us where that person is and article footage of it?
He's sitting next to the defense counsel, or black and white lab coat.
Your Honor, may the record reflect the identification of Nathaniel Jenkins. So, when you arrived at the defendant's residence, was the defendant
Objection to the form of the question. There's no foundation and there's no offer proof that that was his residence, Your Honor. That's what I'm talking about. All of this is a presumption.
That's the thing. I was just saying that we don't know whose house it is because that definitely is relevant as to the charge here. And then testimony shows he was out.
arrived at this location of the search, was anyone at the location?
Once we made entry, no.
And were you by yourself or as you had stated with your team when you arrived there?
With our team.
Do you know roughly how many people are on your team?
At the time.
Is this a home or apartment? Can you describe the location, residence?
It was an apartment.
Can you please tell people, report, excuse me, how you made entry into this apartment building?
I believe I was, number 2 or 3 in the back. But as we get up there, knock on the door and announce a police search warrant.
You knocked on the building door?
Your Honor, just for the record, so the record is clear, because this transcript is important, this is the man. I'd like to talk about what he did, and when he used the concept we, I would ask him to identify who was we, and did he personally knock and announce, and exactly what he did, and not what somebody else did.
Or what you observed?
Right.
Okay, yes. I'm gonna rephrase. Did you observe how entry was made?
Yes.
How was, how did you observe the entry made into the apartment building?
So the first entry door, the common door, was unlocked keys that were found on the suspect's person.
Okay, so which suspect are we referring to that keys were obtained from?
Mr. Jenkins.
Okay. So keys were obtained from Mr. Jenkins that were used on the first door of the building, you're saying?
Yes, the common entry door.
Okay. So you observed these keys being used on that building door?
Yes.
Once inside the apartment building using Mr. Jenkins' keys, did you go to a certain apartment?
Yes.
And were these keys used on that certain apartment?
Yes.
Okay. Did they unlock any locks on that certain apartment?
Yes.
Did these keys that you obtained from Mr. Jenkins unlock anything else in this apartment building?
Yes.
What was that?
The mailbox.
A mailbox?
Yes.
Okay. Was this mailbox affiliated with the apartment that you did the search for?
Yes.
And do you recall what number that apartment was?
Apartment 8.
Once you entered, I assume, did you enter the apartment, sir, with your
Yes.
team?
Yes.
What is the first thing that you or you observed your team do when you entered the apartment?
Cleared the residence or apartment for any other occupants, secured the location.
And to confirm, was there any other occupants?
No.
Can you describe for us, just so that we can get a visual of what the layout of this apartment is?
It's like a 1-bedroom apartment.
Do you recall? Are you guessing?
No.
Yeah, he's giving an answer, and now she's.
She's like, he's like, it's light.
Well,
I
you
don't know
don't
what
believe that
it's like.
witness?
Well,
He
it's.
said one bedroom.
What's the objection?
He said it's 1-bedroom apartment, and now she's trying to cure what she believes was a defect by leading a leading question.
Well, the response could hurt her. He said he is guilty. But
Your Honor, I just want
him
to make sure he said it's light. So to me, I need a definitive. If he doesn't know, he doesn't know, but it's light.
That's all he has to say. If you don't know, you don't know. He's been in office for 7 years. He does not have to be coached from this side of the courtroom. He gave him 1 bedroom. Now, you know it was not 1 bedroom. It's an offer approved, and you're trying to cure the defect.
Frank Page.
Thank you for your testimony. I didn't say that.
Right, no, he's one of the attorneys who said they know what it is. So, I the objection, because he said, like, she can ask if he's sure or not, answer, he's under oath, so he can give the answer that he's sure.
Officer, are you sure of the layout of the apartment?
No. I have to review my video, the walkthrough video to determine, but the apartment was smaller in nature. It was not a big apartment.
Sorry, I have to say, I have. There's a report here that refresh his memory. And due to the fact that it's merged with other officers, information, I will not ask officer to review it, just would be appropriate. So, sir, if you don't mind if I continue. Officer, so once inside this, you said small apartment, what was your role in conducting the search warrant?
Take photographs.
Is that all you did?
Took photographs and helped search the residence.
Did you recover anything while taking photographs and searching the residence?
Yes.
Did you recover anything that is relevant to the charges that have been brought up against the defendant today?
Yes.
What did you recover, sir?
Ammunition. And there's also narcotics.
Did you recover the narcotics?
I photographed the narcotics.
Okay. Did you photograph? So let's start with what you actually recovered, and then we'll discuss what you photographed. So what you recovered, you said ammunition. Can you please tell us what type of ammunition?
It's various rounds of ammunition.
Where did you recover these?
They're in the kitchen, under the sink, the cabinet.
And did you take, you mentioned photographs. Did you take photographs of this ammunition?
Yes.
Aside from the ammunition that you recovered in the kitchen, you indicated that you took photographs. Let's start there. What items did you take photographs of, sir?
Every item that was seized.
Pardon me?
Every item that was seized on the tab, the tabulation. And then I also took other photos of residency, narcotics packaging, scales.
Okay, so you mentioned proof of residency. Can you please tell us what type of proof of residency did you observe in this apartment that you took photographs of?
There's various items of residency, but one in particular was a Xfinity or Comcast bill with Nathaniel Jenkins' name on it.
Okay. Was there, where was this piece of mail with the cable bill located?
That was in the kitchen,
Okay.
next to the microwave.
Was there any other, you said various, that was particular, any other mail?
There's another mail found in his bedroom.
Objection, Your Honor, to the answer to his bedroom. Crossing.
I understand the objection, so I'm sustaining. Ms. Parrish, the witness cannot speak to what he does not know, and it's assuming that it's his bedroom. So he may rephrase the question, that was straight.
Without indicating
I can look at my report, I can tell you what room number or letter.
well, if you could just state without saying whose it was, which room did you find the other mail? What I mean by that is like living room, kitchen, closet, bathroom, bedroom, without actually saying whose it was.
The bedroom.
Okay. Where in this bedroom did you locate this mail?
It was in a box with the various other mail.
And was anyone's name on this mail?
Yes.
Whose?
Nathaniel Jenkins.
How many pieces, give or take, would you say of mail did you find in this box in this bedroom?
I put in the photo. Recall.
More than one,
Yes,
more than five?
yes.
Where exactly, in the bedroom did you say this box of mail was?
I don't recall.
So speaking of this bedroom, can you describe this bedroom to us so that we can get a visual of what this bedroom looked like?
I don't, you come into the apartment, go to the left, it was the very back bedroom.
Was there a bed in this bedroom?
Yes,
Okay. What other items were in this bedroom?
clothing,
What type of clothing?
men's clothing,
Men's clothing? Okay. Is there any particular clothing that stood out to you for any reason?
yes.
What?
The jacket that Mr. Jenkins is wearing was found in a photograph at the residence.
The jacket he is wearing today?
Yes,
Okay, it was found where?
at the apartment.
Okay. In that bedroom that we're talking about right now?
Yes,
So aside from Mr. Jenkins' mail, his keys that he used to enter, the jacket that he happens to be wearing today here in court, you took pictures of all these items, sir, as you indicated? Was there anything else that you may have found or took photos of?
I also took videos of the keys demonstrating opening the common door, the apartment door, and the mailbox.
I know you said that you, these are all the items that you had either recovered or found yourself. Did you end up taking pictures of things that other officers recovered?
Yes,
Were those photographs placed into evidence, sir?
yeah.
Was there anything else that you yourself, not that you actually took photos of, but you yourself either observed being recovered or that you recovered yourself?
I observed the narcotic that recovered out of the mailbox.
So is this when
I'm
you
sorry,
were
can you repeat that? You said you recovered.
I observed the narcotics that were recovered out of the mailbox.
No, thank you.
So, this mailbox is the one that you indicate the keys that Mr. Jenkins, were, for Mr. Jenkins' keys that when you tested the opening the mailbox, what did you observe that was in that mailbox?
Inside the mailbox, there was a Lysol container, and then inside the Lysol container was various narcotics and packaging material inside of the container.
Do you recall which officer, ended up recovering those, items that you recovered from the mailbox, associated with this apartment?
There's a Detective Perrin and Detective Brooks.
Say that again?
Perrin and Brooks.
They recovered the items in the mailbox, or did you recover?
They recovered it. I was there also and observed.
You mentioned earlier, with items that you photographed, you mentioned a scale. Where did you photograph a scale, sir?
I'd have to look at the report to see exactly where.
Was there anything aside from the scale that you photographed? And the other items, and I'm not disregarding the other items that you've already mentioned, but that you have not mentioned before?
I know there's other items on the tab, but I had to look at my report to refresh.
And I apologize, Your Honor, the only report I have has other officers is Karen, so therefore I'm unable to rush covering this time.
I have a copy with me.
Do you?
If it's shown to Attorney Page.
Can I approach, Your Honor?
Sure.
Officer, you could please take a look at your report. Please do not read directly from the report, but once your memory is refreshed, let us know. We'll continue. Questions? Is there anything else that you recovered or took photos of and actually observed the recovery?
I took a photo and recovered a magazine, gun magazine.
Do you recall where that gun magazine was?
I looked at the report.
Please, Your Honor,
May you refresh us the recollection?
would, if that will refresh your
Yes.
recollection?
Okay.
Where did you take a photograph of the magazine?
It was in the kitchen inside of a empty tinfoil container.
I'm sorry, could you say that again? Where in the kitchen?
Inside the kitchen in a cabinet, inside of like a foil packaging, inside of the box.
Do you recall the type of magazine it was, sir?
I don't.
Do you recall, was it an empty magazine? Was there ammunition in it?
Empty magazine.
Was this found along with the initial ammunition that you spoke of that you had recovered in the kitchen?
Yes.
Were they together or in different locations in the kitchen?
Different locations.
Just one last question, Officer Tasker, or Trooper Tasker. These photographs and items that you recovered, were they placed into evidence, sir?
Yes.
No further questions at this time. Thank you.
It's Trooper Tasker, right?
Yes, sir.
For the state troop? What's your state police?
Yes.
You're part of the task force, right?
Yes.
Or you were part of one?
I still am.
Okay, you still are. And you know it's important that you testify accurately and truthfully, right?
Yes.
You're subject to the same rules as anybody else taking the stand, right?
Yes.
You understand that, right?
Yes.
So, I want to be careful when you respond to my questions, all right? And you don't understand my question, I'll try to put it in a manner that you understand, right? Okay? This address, that you executed the search warrant, were you the offend on the search warrant?
Was that the what?
Were you the one that swore out the information on the search warrant?
No.
Okay, you wasn't part of that. Was there a person named to be searched in the search warrant?
Yes,
Okay, and who was that?
Nathaniel Jenkins.
Okay. And at the time that you reached the premises in which you executed the search warrant, was Mr. Jenkins on the premises?
No,
Okay. And there have been occasion to strike that. Isn't it true that Mr. Jenkins was falsely arrested in Southgate and brought to the premises?
he was arrested in Southgate, but not falsely.
Were you there when he was arrested?
Yes, I was the one that arrested him.
You arrested him in Southgate?
Yes,
And you arrested him based on what?
he's named in the search warrant.
So the search warrant gives you permission to arrest a person prior to you finding any contraband or drugs or gun or ammunition. The fact that you have a search warrant gives you the right to arrest him. Is that what you're telling Your Honor?
Yes,
Okay. And so if you're wrong about that, you heard of the fruit of the poison tree, everything else falls. You understand that,
Your
don't you?
Honor, they're actually two separate incidents. We have a search warrant.
No,
He wants
yeah,
to argue
she
the
can't-
search warrant.
Let
can't
her
justify it.
objection on the record.
Your Honor, he's asking him questions about that I would argue relevance in the fact that the search warrant is separate of the suspected detainment or arrest of the defendant. Now, if he wants to ask him questions that are related to the search warrant, okay, but he knows that the search warrant is
It's all part of the package. If he doesn't have
you can't argue that
you can't
the
argue
search
with me, you can
warrant
argue
was
with me, you
not.
gotta address the judge, but it's part of the package.
So I am going to allow, as True just stated, that the search warrant is attached to the arrest that he conducted. Now, as far as how wide open the question will go, that's going to be up to you to object. But right now, based off of this, he's just asking about proof of poison street view. As lawyers, you often argue with that, how that would play out, but him just asking the connection between executing the search warrant and arresting Mr. Jenkins, I will allow, since he was the one who arrested Mr. Jenkins.
You arrested Mr. Jenkins, isn't it true, before you executed the search warrant, right?
yes,
You arrested Mr. Jenkins before you found ammunition at the residence in which you executed the search warrant, right?
yes,
You arrested Mr. Jenkins before you purportedly took keys off of him, that's before they opened the mailbox, right?
yes,
You arrested Mr. Jenkins before you, by the way, you said that the way that you got into the premises in which you executed the search warrant, the common door was open. That's what you told Your Honor, right?
no, we opened it.
When you say we opened it, who is we?
Our team,
Who is our team?
Metro Narcotics Enforcement Team. I don't know exactly who opened it.
Well, when you say we opened it, did you see the person that opened it?
Yes,
Okay, name the person for the record.
Detective Parent.
Detective Parent, okay. And then Detective Parent was the first one to enter the premises, into the common area,
Yes,
okay, and who followed him?
the rest of the team.
The rest of the team. And how many people was on the rest of the team?
You want me to name everyone?
I said, how many people? I didn't say name the people.
8,
Did you say 8?
8,
Okay. So when you got to the apartment, you told Your Honor, and I want you to understand, I just want you to be careful with this. You told him that you used a key taken off the defendant to enter the apartment, right?
yes,
The truth of the matter, you kicked the door in. You kicked the door in, officer.
That question?
Yes. You kicked the door in, didn't you?
did we force entry? Yes,
Well, isn't there a difference between forced entry and? Isn't there a difference between forced entry and entering by a key? See, you perjured yourself, didn't you?
no,
Okay.
let me explain.
No, I'm asking you, you you testified under oath on direct examination that you used the key purportedly taken off with this gentleman to enter the premises. Did you do that under oath, under direct, yes or no?
We did use a key
No, no.
to unlock the deadbolt of the door,
No, this,
but the second key did not open the bottom. So for our safety, we forced entry into the residence.
so you wanna,
But the keys still
you
work.
wanna yabba dabba do, you know my question was this, you told your honor that you used a key to enter the premises on direct, and you didn't clarify no information about a deadbolt or anything. You didn't tell your honor that you kicked the door in, did you?
The question wasn't asked.
Well, it was just asked, you kicked the door in, did you?
We did kick the door in.
You told your honor that Mr. Jenkins had a bedroom on these premises, right?
Yes,
Was the apartment leased?
I don't know.
Did you ever run a check and see who owned the premises or who was leasing the premises?
No,
Did you ever run a check and see who had electricity in their name,
no,
the gas in their name?
no,
Who paid taxes on the building?
no,
Who paid the water bill?
no.
In fact, you never seen this man sleep on those premises, have you? Have you?
Well, there's tracker data and
Well, I said,
cell phone
have you?
GPS location.
I said, have you ever seen him sleep on those premises?
No,
And the fact that a person has a cable bill on a premises don't infer that they live there, does it? Does it?
good.
It could, which means they could not, right? I mean, it's either or. If it could, I mean, it could not. You get that kind of common sense, right?
Well, my address goes to my residence and that's
Well,
where I
if
live.
you're not on trial, right? You're not on trial, are you?
No,
Or are you?
but
Objection, Your Honor, he's asking him for his opinion,
I will.
for him to actually make a guess, and that's what the officers kindly given for.
I will. Listen. Did you do any fingerprint analysis on the ammo?
no,
Did you do any fingerprints analysis? How was the drugs contained? Was it in a baggie? Were they in baggies?
it's in various plastic bags.
Ziploc bags? Did you hear my question?
I said various plastic bags,
Were they Ziploc?
not like sandwich bags, not Ziploc.
Okay, sandwich bags. Are you aware of any fingerprint analysis tracing those bags back to the defendant?
No, we don't do that.
Well, when you say we don't do that, you mean the Michigan State Police never analyze baggies or containers to determine if there's fingerprints on it? Is that when you say we, are you speaking for the Michigan State Police and the police line?
We don't do fingerprints to test for narcotics packaging,
Who is we?
the MSP.
Okay. And you are, okay, I'll take that answer. And so you don't have no proof that he ever touched those baggies? None.
No,
You have no proof he touched the ammo. Right? You have no proof he touched the ammo, do you?
no,
You have no proof that he was aware that the ammo was in the house, in the apartment, do you?
no.
Now let's get back to this arrest in Southgate. You arrested him based on the fact that you had a search warrant. That's what you told the Army, right?
Yes.
And that search warrant did not say search and arrest, did it? Have you seen the search warrant? You know what a search warrant is? Do you know what a search warrant is?
Do I know where it's at?
I said, do you know what a search warrant is?
Yes.
Okay. The search warrant didn't say arrest Nathaniel Jenkins before you had probable cause to arrest him, did it?
Can still detain him.
No, you told Your Honor that you arrested him. Those were your words. And not only did you detain him, you kidnapped, transported him from Southgate to Detroit without probable cause, didn't you? You transported him from Southgate to Detroit without probable cause, didn't you?
Your Honor, I'm gonna object to this because, based on the earlier, I believe defense is bringing evidence, not yet that was testified to. I don't believe.
He's testifying to right now. He's my witness right now.
I understand, but, there was anywhere stated that someone was, transported. As a matter of fact, I believe, the officer indicated that he wasn't transported.
Yes or no?
He was transported.
It's been asked twice already, so you just answered yes.
You arrested Mr. Jenkins, right?
Yes.
Listen to my question.
Been asked twice already.
Yeah, you arrested Mr. Jenkins in Southgate.
Yes.
And you took keys off Mr. Jenkins without probable cause, right? I mean, you had no reason to take keys off Mr. Jenkins, right?
The search incident to arrest.
A search incident to arrest. You took keys off of him without a reason to have him arrested. Just yes or no, and I'll move on. I got what I need in the transcript. I mean, you took keys off of him without a reason to arrest him, right? So what part of that is hard? I'll move on. I know for the record that he did not answer the question. And again, I subject you, officer, to the fact that you are under oath. There's a transcript of this, and I presume that this might be bound over, and you're gonna see me again. So I want you to be very careful with your answers, all right? You understand what I'm saying?
Yes.
Prior to your testimony, today, you conferred with your team, right? Out in the hallway, you all talked about the case, right?
Yes.
And you talked to the prosecutor about the case, right?
Yes.
So prior to your testimony this morning, you was familiar with the salient facts about the case. I mean, you have already refreshed your memory about a lot of issues, right? About the case, right?
Yes, yes.
Prior to the execution of the search warrant, you had never seen Mr. Jenkins on the premises, right? Right?
He was observed on surveillance.
I mean, had you ever seen him on the premises? That's not my question. It's not difficult.
What is the question? Has he ever seen him?
Have you ever seen Mr. Jenkins on the premises before you even arrested him?
No.
And when you arrested Mr. Jenkins, he had a driver's license on him, right? Right?
I don't recall.
Wouldn't that be? Did you have an automobile?
Yes.
Did you check and see where the automobile was registered at?
No.
You did that because it's not important to you, or is it one of those other catch-all, we just don't, Michigan State Police just don't do those kinds of investigations?
I'm not the OIC of the case.
So whatever you did do, you're gonna say that OIC should have done it, right?
Well, this is the OIC's case. And
Who was OIC?
Negative parent.
Was the cable on in the house? I mean, isn't it true that the cable had been detached? I mean, it had been turned off?
I don't know.
You don't know that. You're talking about a cable bill, and you don't know what the year is on the cable bill, what the date is on, even if the cable was still operational. You don't even know that, do you?
No, we didn't turn the cable
And I'm
on.
not saying we, I asked you to talk about what you did. You don't even know if the cable was on, do you?
No.
Something further.
Clarify, since defense brought up the arrest. What's he suspected of doing since you arrested him?
Objection to.
You brought up the arrest. I want to know why he was arrested.
Listen, Your Honor.
What's the objection?
The objection is hearsay.
He arrested him. You asked him about the arrest. You brought it up. You opened the door. I want to know now why he was arrested. I didn't bring it up. You brought it
The
up.
door is clear that it's an illegal arrest. So I'll take the answer. Whatever he says is in the transcript.
I don't believe it's that
Okay.
clear at all.
Just to respond, defense counsel asked several times about the arrest, he even asked if he had probable cause to arrest. And on redirect, she can address whether or not the trooper had probable cause and based on what. So,
What was the question?
Why did you arrest him? What's the incident that led to his arrest?
Narcotics trafficking?
Was there an incident that led up to it aside from just assuming?
This is just a whole investigation and the search warrant. The investigation of the overdose causing death.
There was an overdose?
Yes.
Objection to hearsay and relevance, Your Honor. And it didn't give him, and again, it didn't give, he's filing the issues here, it didn't give him a basis to arrest this defendant. If there's an overdose cause that he was involved in, it's a different kind of case. Your Honor, it's not relevant to this case.
I agree. That's why I didn't bring up, but he brought up why he was arrested, so I wanted to find out, which obviously then led to a judge signing a search warrant that felt that there was enough probable cause for there to be a search warrant, and you brought it up, so I want to know, what was he a suspect
She's
of?
testifying. She's testifying. There's no issue about a probable cause relative to why the search warrant was executed. And even if the search warrant was executed, it didn't give them the right to arrest him without them finding reasonable suspicions of a crime at the time of the arrest.
And that is why I'm asking, what was he reasonably suspected of doing?
Selling narcotics?
Okay. No further questions. Thank you.
Yeah, and I think the court understands my position on this, and I don't need to ask any further questions about this. The law is straightforward on this.
Yes, Your Honor. I'm gonna try to keep these other witnesses brief since we've already laid the foundation of search warrant and everything.
I disagree that the foundation of the search warrant has not been laid, and that the FIN audit has not been made. There's no foundation for the search warrant in the record.
Let me rephrase, I apologize. That's not what I meant.
An argument, I have the notes, I'm writing very, detailed notes here about what has been testified to. So
Thank you, Your Honor.
I'll let you all argue that out after testimony.
The people called Officer Nicholas Stavicus.
Yes, sir.
Thank you. Okay, raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Go right in front and make sure you speak up in the back.
Yes, ma'am.
Whenever you're ready.
Good morning, officer. I'm gonna ask you a series of questions, if you could kindly just speak into the mic. And if there's anything I ask that you don't understand, please stop me. I'm happy to rephrase. A little hard of hearing, so you're more than welcome to move the mic to make it easier for you to speak right into.
Okay.
Could you please restate your name for the record, sir?
Yes, Officer Nicholas Amicus.
Officer, where are you currently employed?
I'm employed by the city of Wyandotte.
And in what capacity, sir?
I'm a police officer.
How long have you been a police officer?
In July of this year, it'll be 9 years.
Have you, while being a police officer, had any specialized training?
Yes, ma'am.
What type, you name a few that would be relevant, to this case? What
Yes.
type of training?
I went to Desert Snow, which is narcotics training. During my time at Wyandotte, I've been assigned to our special operations unit twice, which typically deals with narcotics.
Thank you.
Yes, ma'am.
As a police officer who's trained in narcotics, were you employed in this capacity on February 2nd, 2022?
Yes, ma'am. During that time, I was in our special operations unit, city of Wyandotte.
Did you have let me just ask, were you in a uniform on that day, sir?
On that day, I believe I was in plain clothes. But I did have police markings.
And what type of police markings?
On my vest, both on the front and the back. I had bold letters that state police. I believe I have a long sleeve shirt with both sleeves, again, state police on the side.
Okay. And were you by yourself or with the unit that day?
On that day, I was working with MNet, Michigan State Police Narcotics Unit, MNet.
Okay. And while working with the state police, on that day, did your duties as Wyandotte police officer take you at or near the location of 2683 Central Avenue, Apartment 8, the city of Detroit, County of Wayne?
Yes, ma'am.
Why were you at this location, sir?
I was at the location that executed a search warrant.
And when you were executing a search warrant, did you enter the location with the other, or were you, I know you said you were with the unit. Do you recall how many people were with you at that location?
I don't recall the exact number. I know it was greater than 5, but yes, I was with them.
Okay. And did you enter the location?
Yes, ma'am.
Once you entered the location, officer, what was your role in this, in conducting the search warrant?
So when I entered the residence, we made our way up to, I believe it was the 2nd floor. I was part of the staff, so being part of the staff, we went in, located the apartment. Once we made an entry, I assisted with securing, making sure no one else was in the apartment. Once that was done, I assisted with searching the apartment.
While assisting with searching the apartment, did you happen to recover anything that, that is relevant, to this case I have?
Yes, ma'am.
Could you please tell us, what did you, recover in general, and then we'll get into details.
Yes, ma'am. I recovered U.S. currency and 21 white pills, later identified as oxycodone. That was in the kitchen of the apartment. I also recovered a knotted cellophane baggie, from the rear bedroom of the apartment.
Could you repeat that, a what?
Sorry, a knotted cellophane baggie. And that was in the bedroom of the apartment.
So let's get into a little bit of details. This knotted cellophane baggie, can you describe its contents and what it looked like?
Yes, ma'am. The knotted cellophane baggie contained an off-white powder, which was later identified as.
Objection to hearsay, Your Honor.
I haven't heard you say yet. He didn't finish what he was stating, but
He said it was later identified as, and it infers that he's relying upon something he's heard.
I can stop there and ask some questions to lead up to that. Sir, based on your initial observations of this and your experience in training as a narcotics, did you have any idea of what this off-white, you say powder was?
Yes, ma'am.
Okay.
Due to my training and knowledge from prior incidents, I believe the off-white powdery substance was consistent with that of cocaine or fentanyl.
So you say either cocaine or fentanyl. Was there any did you observe any preliminary analysis on the scene done with this item?
Not to my knowledge.
Okay. And was this powder that you located eventually put into evidence or sent off for analysis?
Yes, ma'am.
Both those, was it placed in evidence?
I apologize.
Was it placed in evidence?
Yes, ma'am.
Was it
Placed
sent
in
off
evidence.
to
Yes,
analysis?
it was later sent for analysis.
Are you aware of what the analysis from the lab came back as?
Call for hearsay, Your Honor.
Your Honor, it's already placed into evidence as proposed exhibit, so I can read it in if they prefer, but.
Well, they prefer, and I ask that hearsay not be offered, Your Honor. She's referring to me as they, the defense, but I prefer that we not give it to hearsay.
Go ahead and enter it in evidence.
But, so we don't need an answer from this officer about hearsay, because whatever comes out of
It's
his
not,
mouth,
so what's been entered is not hearsay.
absolutely.
Was an exception, I should say, to hearsay rule.
Right,
An
right, so
example.
that's it, but we don't need an answer for him about something that he don't know other than based on hearsay. The report is in evidence itself. I'm asking that he not offer hearsay. The only way that he knows about the results is somebody told him the results, and that is classic hearsay.
Or he reviewed the report that's been entered.
Well, then we don't need it twice.
Well, she can't, I mean, she's trying her case. If she wants to explore his knowledge about the report that's been entered, he can do so. But I understand your hearsay objection is based off of something outside that report that's been entered, that he did not handle or review. I understand.
Your Honor, I'm happy, it's fine if you want to strike whatever was said after the fact that it was sent to the MSP lab forensics, and I would indicate that preliminary matters indicated item 1 that was tested, and item 2 that was tested, one coming back as cocaine, one coming back as fentanyl. I would like to explore a little further, Officer. Can you describe, you said it was a baggie. Was it just powder inside, or was there anything else distinctive about this baggie?
To my recollection, it was just a corner of a cellophane, essentially a sandwich bag, that was knotted. Inside, I could tell that there was a off-white powdery substance. If I may, to give reference, I would say the size of it was approximately like a nickel. You made a nickel into a sphere, as far as the amount.
That was it.
Thank you. As you mentioned that you also located other narcotics aside from the white powder. Can you please describe, or well, before we go on to that, let me just, and I apologize, I don't want to put words in your mouth or assume. Where exactly did you locate that powdery substance?
That was inside of the box, which was inside of the bedroom of the apartment. It was a small wooden box, though.
Do you recall where in the bedroom that was?
No, ma'am, I do not.
Was there anything else in that box along with these suspected narcotics?
I do not recall.
What other item besides powdery white narcotics or suspected narcotics did you locate? You had mentioned some other narcotics.
Yes, I also located a bag containing, I believe it was 21 white pills. They were later identified using pill identifier via drugs.com as oxycodone. There were also.
I'm sorry, where did you locate these 21 pills that were later identified as oxycodone?
They were located inside the cabinet of the kitchen.
From your observations, was there anything else that was recovered or observed near these pills in the kitchen cabinet?
I also recovered the U.S. currency from there. I know other officers on scene recovered.
Objection to hearsay, Your Honor. Or if he actually saw them recover it, if it's based on something someone told him, I ask it not be put into the record or the transcript.
Okay. If you actually observed it, it's one thing.
Yeah.
You learned about it afterwards. Did you observe another officer recovering something near this?
Yes, ma'am.
Did you observe the other officer recovering near this?
I observed a magazine for a firearm that was also recovered in the kitchen.
Was that in, okay. Aside from these two narcotic substances that you recovered, and you said currency and you observed a magazine, was there anything else that you recovered?
Me personally, no, ma'am.
Was there anything you observed recovered by anyone else?
Nothing that comes to mind at this time.
Officer, no further questions at this time. Thank you.
No questions. I don't know what that was about. No questions.
Thank you. Have a good day.
Thank you.
Thanks, sir.
People called Devontae Brooks.
Brooks.
Well.
You swear to tell the truth, promote truth, and nothing but the truth.
That's right.
Okay. Doors in the front here, just make sure you speak up after you sit down.
Officer, I'm gonna ask you just a few questions. If there's anything I ask you don't understand, please stop me. I'm happy to rephrase. Well, hard of hearing, so if you don't mind, to just speak right into the mic. You're welcome to move the mic around or pull it up next to you, whatever's easiest. Could you please restate your name for the record?
Officer Devontae Brooks,
Officer Brooks, could you please tell us where you're currently employed
employee with the City of Detroit Police Department.
and in what capacity, sir?
I'm currently assigned to MNET, Michigan State Police Narcotic Team.
So you're assigned to the narcotics team. Have you had any specialty training
Yes.
involved in this?
Yes,
What type of training?
I've been numerous narcotic schools. I've been to 2 undercover schools. Been in narcotics for approximately 7 years.
Were you employed with the Detroit Police Department in this capacity on February 2nd, 2022, sir?
Yes,
Were you by yourself or with the unit?
I was with a unit.
Is this unit all Detroit Police or MNET?
It was in MNET.
Were you in a uniform on that day, sir?
Yes,
Was it fully marked or did you modify uniform?
modified fatigue. It was like fatigue BDUs, police hoodie, with a black full duty belt.
Were you in the scout car that day?
I was in the raid bin that day.
The what?
I was in the raid bin that day. Prior to the raid, I was on surveillance in a car.
On that day, officer, did your duties, narcotics, and then Detroit police officer gave you at or about 2683 Central Avenue, apartment 8, the city of Detroit, County Wayne?
Question, I didn't hear everything.
I'm sorry. Did your duties on that day take you to the location of 2683 Central Avenue, apartment 8, in the city of Detroit, County of Wayne?
Yes,
Can you please tell us why you're at that location?
we had a narcotic search warrant for that location.
When you arrived at that location, sir, did you enter the location?
Yes,
When you entered the location, sir, what was your role in conducting the search warrant?
I was pretty sure I was assigned to the Halo that day. We didn't have to use the Halo. We was able to get in through the front door with no force. I was a part of the search team. Also,
When you say the front door, are you referencing to the building?
the common door, the
The
building.
common door? Okay, so the common door, you didn't need force?
No,
Okay. Did you eventually need force for the apartment door?
yes,
Okay. Prior to using force, did you have any other method of entering? The common building or that door?
no, it was the common door, and we took the stairs to the apartment 8.
And sir, once you were inside the unit, what was your role in the conducting the search?
I was assisting with searching the location.
Did you actually search and recover anything?
Yes, during the search, yes.
Could you please tell us in general, and I'm happy to get into detail, what items you recovered that was relevant to this case?
I recovered fentanyl and cocaine from mailbox 8 with a key. It was inside of a Lysol bottle.
And when you say mailbox 8, is that affiliated with the search warrant to the apartment?
Mailbox 8 matched apartment 8, and the key was used to open it.
Okay, where did you obtain this key, sir?
It was obtained, I didn't obtain it, so I really don't know exactly where it was obtained.
And could you please describe, once you opened the mailbox affiliated with apartment 8, what was inside?
It was like bundles of narcotics, lotto folds containing narcotics.
Say that again?
It was like bundles of narcotics and lotto folds containing narcotics inside the Lysol bottle.
Is that a Lysol bottle?
Yes.
This packaging, you said multiple, I'm sorry, could you describe these folds?
It was like a lot of fold, some fresh narcotics. It was more of a seller amount, the way it was packaged.
So, when you say a seller amount, so, in your experience as a narcotics officer throughout the years, the amount that you found of, both suspected fentanyl, cocaine, and that Lysol, was that, indicative of personal use?
No, ma'am.
And you said the packaging was folds, anything else about the packaging, sir?
I think it was also like, something, if I'm not mistaken, for my report, please.
Say that.
For my report, please.
What did you say? You found what?
It was, like, they were like in a bundle. I'm not sure, I think it was like a chunk of cocaine, ready to be cut.
Okay, I didn't hear you.
May I approach, Your Honor? Yes. I showed you the portion of this report that has your name indicated. Would that help you refresh your memory?
Two large plastic bags containing various types of packaged narcotics.
So your memory has been refreshed after
Yes.
looking at that? And that's what your report says, but you specified a little bit more detail under oath. And let me ask you about the details. Once you recovered these items that were inside this place of law, did you place these into evidence, sir?
It was placed on evidence.
Were they sent out to have any analysis done?
The preliminary test was done, and it was also sent to the Michigan State Police Lab.
Your Honor, again, that references to the second item, the fentanyl that was read into record of the MSP lab report under 766.111A is was exhibit 1. Officer Brooks, aside from the fentanyl that you recovered, or the suspected fentanyl that came back from MSP lab, in the mailbox associated with the apartment, was there any other items that you recovered out of that apartment, sir, relevant to this case?
No, ma'am, not that I can remember off the top of my head.
Did you have the, after placing these items into evidence and sending them out for lab analysis, did you have any opportunity during the course of your investigation to speak to anyone suspected involved in this search warrant?
Yes.
Okay, who was that?
Nathaniel Jenkins.
Okay, would you be able to identify that person today if you saw them?
Yes.
Are they in the courtroom?
Yes.
Could you please tell the court where they are located and the items clothing they were?
Black male, with black and white jacket, black pants, black and white shoes.
Your Honor, may the record reflect the identification of defendant Nathaniel Jenkins. Sir, did you speak to him before or after the search?
I spoke to him after the search.
Okay. Was prior to you speaking to him, did you provide him his, Miranda warnings and rights.
Yes.
At any time while speaking to him, did he indicate that he wanted a lawyer or refuse to, provide you any statements or information?
No.
Did he willingly, speak to you in regards to the search?
Yes.
Did he, indicate anything in regards to the apartment that you searched?
It was an audio conducted, and he stated to me that he does not stay there all the time. He stated that he have knowledge of the ammo. He has a roommate at that location. He pays, he said approximately $800 a month for rent. They split it.
But you indicated that he told you he was, he knew of the ammunition?
Yes, he said he forgot that it was there. Also, he had the oxys that was recovered from the apartment. He stated that he received them for, I don't know, for accident or something. But he also stated that we actually have a prescription. He said no.
Okay, so he was, he indicated that he was aware, but that he did not have a prescription,
Yes.
excuse me?
Yes.
Okay, and did the defendant indicate anything else in relation to, aside from the oxy and no prescription, the ammunition that you found?
Trying to refer my court police recollection.
And Coach Runner, officer, looking at your report, refresh your memory.
Yes.
Please do not read from the report. Please read it completely. Once your memory is fully refreshed, please let me know. We'll continue with questions. Has your memory been refreshed, sir?
We started on this was the continue. Then the page, please. We started on this page. This was the continue page. We started at the bottom.
You want to say the bottom of this? Thank you. Again, officer, please let us know when your memory has been fully refreshed. Officer, has your memory been refreshed?
Yes.
Aside from the defendant acknowledging that he is aware of the photo and the ammunition, did he convey any other information in regards to your search?
So it was a mistake, it was done leaving in that spot, leaving in that area.
I'm sorry, you said,
So it was a mistake, and it was done leaving in that spot,
what was the mistake?
that's what he said, so
Okay, and leaving what? Did he indicate leaving what in what spot?
that's what he understood.
And, did he provide any information in regards to any other items?
No.
No further questions, thank you.
There's a few questions. You stated to the point that you gave him this Miranda rights.
Yes.
And was that in written form or oral form? You did do it right,
It was audio recorded?
so you didn't do it right.
No.
You didn't have him initial his rights.
I can't hear you, sir.
You didn't have him initial his constitutional rights because it was oral, right?
Yes.
And when you gave this right, were you by yourself?
No, I was there.
And where was this conducted at?
It was at Garden City Police Department.
After you got this reported statement from the defendant, you all let him go, right?
Yes.
Did you have a police video on at the time?
For the injury, I had a body camera on.
You didn't have a body camera?
Yes.
If you know if that evidence was preserved,
No, I do not know.
do you know at the time that you did this, for the interview with the defendant, was your body camera activated?
During the interview?
No.
No, it was audio.
Nothing from you? Further witnesses for the people, Your Honor. Okay.
I need to take a 3-minute break. They were back on the record for Mr. Daniel Jenkins. Mr. Chair, I believe you were getting ready to take the case or argue. Find it.
People move that Ms. Daniel Allen Jenkins be found over on count one, controlled substance delivery manufacturing, less than 50 grams. Count two, controlled substance delivery manufacturing, less than 50 grams. Count three, controlled substance possession, less than 25 grams. And count four, weapons, ammunition, possession by a felon. People reserve argument. Thank you. Okay.
Your Honor, with the court's indulgence, I'm not gonna be long with this. It's not too complicated because there's a couple issues going on here, and the most substantive witness that the people produced, notwithstanding the last officer reporting his confession from the officer testified that they arrested the defendant in Southgate without probable cause. Took keys off of him and taking the keys off of him, transported him, assisted to transport him back to probably what we call a crime scene. The keys that was taken off of the defendant was used to execute the search warrant, which was illegally obtained. The police officer entered the premises illegally. Based on an illegal search of the defendant and arrested him without probable cause. And the profit that the witness gave that he arrested the defendant because he suspected that he might be a drug dealer is ridiculous. I mean, if you're going to arrest anybody that they think that they might have committed a crime, that's totally contrary to our Constitution. And as this court knows, there's a concept called approval of force and trees. Anything obtained subsequent to an illegal arrest, illegal conduct by law enforcement, police agency must be sequestered and thrown out. And if the court were to follow my argument about approval of force and trees, notwithstanding the fact that there's a court confession, you can't confess to something that has illegally been obtained. And in this court confession, it's as nebulous as anything you get it. I don't know what he fully confessed to. And the other, I reserve. That's the crux of my argument, Your Honor. Without Officer Brooks coming in with this reported confession, this case, I was more than 100% confident that it was going to be thrown out, because this is one of the weakest cases in cases involving police misconduct that I've seen in 35 years. But I'm going to sit down and I'm thankful that the courts have given me the indulgence to make the argument.
Well, I don't have 35 years as defense, but in the last year, I would have to respectfully disagree that this is more than meets probable cause based on if we're comparing. But we're not. Let's focus on this case. And people believe that probable cause, which is the standard here, has been met. Let me just, so we can get this out of the way. As far as the fruit of the poisonous tree, it was testified that the defendant was initially arrested, detained, however you want to state it, but let's say arrested as a suspect in drug narcotics that involved an overdose. From that, yes, they obtained the keys. First of all, there was probable cause to arrest someone. We didn't get into the details of what that probable cause is. Therefore, I don't believe that defense has met any type of burden to indicate that there was fruit of the poisonous tree. But let's entertain it for a second. if it was, the only thing they obtained from him were the keys that, helped prove residency and showed, that they were able to, get into the apartment. Without the keys, they still were getting into that apartment. They would have just forced entry.
What about the mailbox?
Right, well, and they would have forced entry on that as well, Your Honor, because the mailbox is directly linked, mailbox 8 is directly linked to the apartment, and therefore they would have been able to obtain that nonetheless. So, again, that is part of the probable cause, but the people have more than just that probable cause as far as proof of residence, and not just the keys that, again, we believe is not part of fruit of the poisonous tree. We believe that should still be taken into consideration. But aside from the keys that were taken from the defendant that opened up all of the doors, once inside, was testified to that various mail, not just one cable bill. Yes, he said specifically, he mentioned a utility cable bill, but he indicated that there was various mail addressed to the defendant. That various mail, when I asked, it was over 5 pieces of various mail. Aside from that, he also described, besides the mail, the clothing. This alone, the jacket that the defendant is here in court today was testified to being a jacket in that bedroom of that home that he is wearing today. Aside from that, going further, Officer Brooks took a statement from the defendant, where the defendant indicated that he rents and that he has a roommate, and he admitted knowledge of some of the items, namely the oxycodone and the ammunition. So that alone shows more than probable cause, proof of residency, showing that he had control and dominion of the items of that apartment. And as far as, aside from the proof of residency and having control and dominion of those items that were all found, constructive possession does not mean just one person. So even though he might have had a roommate, which there was no roommate found there, but in his admittance to the officer, he admitted that he rents there. What the people believe is his bedroom, due to the fact that mail was found there in that bedroom, aside from the suspected items, but his clothing that again he's wearing today. Aside from that, he indicated that he pays rent and therefore control and dominion of the items that were recovered in that apartment can directly be linked to him with proof of residency. He was ID'd by the arresting officer, Officer Tasker. He was also ID'd by Officer Brooks, who spoke directly to him and obtained the information, the statements admitting him paying rent at that location and his knowledge of some of the items that were recovered. We don't need him to actually confess to all of the items, Your Honor. This is a probable cause hearing. It's a question of fact of everything else that should be determined by a trier fact. But as far as probable cause, all of these items were located in his apartment, the apartment that he admits paying rent to, the apartment that that not only did he have keys, but there was multiple proof of residency mail that was found in that location, and the jacket that he is wearing today in the apartment. As far as the more details as far as possession with intent to deliver, officers found scale, found various packaging of the narcotics that were located, and just the mailbox alone, the Lysol bottle, and having these the various packaging in this Lysol bottle. Perhaps maybe he thought that, oh, this is not his apartment, but the mailbox is directly linked to that apartment, and therefore it is part of the search, and which is under his control. Because it is his apartment, that mailbox is his apartment, and the mail that found in there is also to that apartment. So those items, the fentanyl, the suspected fentanyl, the cocaine that was also found, and the ammunition, all of these items would count, that goes towards the counts that he's been charged. Specifically count 1, the controlled substance cocaine, preliminary matters we read into the record. Count 2, controlled substance of the fentanyl that came back as positive for fentanyl that was found by Officer Brooks, as he indicated. And more specifically, Officer Brooks went into detail based on his narcotics training and experience, the way the packaging and the amounts were that were located at this location that the defendant has control and dominion of are not indicative of personal use, but rather that of intent to deliver. And lastly, count 4, weapons and ammunition, possession by a felon. On preliminary matters, we did read that the defendant is a convicted felon and is not allowed to have ammunition. So even, again, he admitted to knowledge of having that ammunition, but even without that ammunition, he has control and dominion over his apartment. That ammunition is found in the kitchen. Therefore, by probable cause standards, we believe each of the counts of probable cause has been met and ask that they be found. Thank you, Your Honor.
Yeah, I know I don't get a second chance, but I just want to say for the record that there's nothing in the record to support that the search warrant itself was developed into record.
Wait, say that, I want to be very
But
clear.
the search warrant itself, there's nothing, no testimony that it named the mailbox as part of the search warrant.
Your Honor, it's a question of fact as far as the search warrant. If he feels that the search warrant was not, it's part of curtilage. Most everybody knows in a house, curtilage and the search warrant is added. We did not put the search warrant into, but again, that's a question of fact. He's happy to argue it over there. If that's the case, he can get it thrown out.
There's no argument, I mean, there's no testimony about curtilage. You never asked a question about curtilage. You never asked.
I'm just confirming, there was no testimony from the officers that the mailbox was included. Argument, yes, I understand, the case law on curtilage. As well as curtilage, there was nothing on testimony about the officer stating it was part of curtilage based on.
Correct, Your Honor.
In the common area, no testimony, that's what officer, officer, and Attorney Page has stated.
You are correct, but because it was an apartment building, I think with probable cause, we can assume that that was included, seeing how that the mailbox is in the building, of which the address is, like as stated, common area that is directly related to, again, that apartment.
But that would be good if you were testifying. You never got that out of the witness.
Again, probable cause standards, question of fact, if it comes to light during a trial, that was not on the search warrant that was signed by a magistrate. At that time, the trial fact can determine if that should be taken out. But at this point, probable cause has been met.
And I
Yes,
been duly
to
noted and recognized Attorney Page that that was not his testimony. So I will try my best to not draw this out as long as it needs to be. I do believe that question of fact has been presented that the circuit court will have to address regarding Attorney Page's argument of proof of the poisonous tree and whether or not the arrest was based off of probable cause or was legal in some. On direct, Trooper Pastor stated that the defendant was arrested for search warrant and nothing else. On redirect, he said that he was investigating and it was based off of the drug overdose and some of the narcotics. That's where the question of fact comes in. I don't think it's quite clear, and I don't also think that at this stage, the prosecutor and defense were trying to necessarily get into all the details of that search warrant. So that would be for circuit court. I will bind it over, but I do want to get on the record as to why. In the event that, let's say, which third circuit will have to address as far as who's the poisonous tree. One of the exceptions would be inevitable discovery. And the officer, tasker, or staff, I can't remember which one, testified, tasker testified that they had to force entry into the location because there was a dead mole on the door. There'll also be a question, in fact, as to whether the mailbox would be considered or was included in the search warrant. So there were several items I would describe as intricately placed throughout the apartment that Mr. Jenkins admitted to residing in along with a roommate. I'll start with the non-mailbox items. There were nickel-sized knotted cellophane baggies that were sent off and analyzed to come back with cocaine and fentanyl in the one bedroom that was described. Trooper Taskers was not sure if there was a second bedroom. However, the bedroom that the cocaine and fentanyl in the nickel-sized knotted cellophane baggie was the same room that Trooper Tasker described the black and white jacket that matches. I don't believe you can say whether or not it's the exact jacket because it's a duplicate, but described as the same design and color as the one the defendant had on today. There were different types of ammunition found in the kitchen under the seat cabinet. There was a scale found. I don't believe there was testimony as to where in the apartment. Also, U.S. currency. It was not determined what the denominations were, as well as where the money was found. But also in the kitchen cabinet, 21 Whitefield oxycodone that the defendant claimed to know of and have possession of without a prescription. And to go to residency to establish that the defendant had knowledge and constructive possession, ability to have dominion and control at some point, because he was not there at the time of the search warrant, but based off of his residency and stating that he lived there as well as the pieces of mail. There was mail in the kitchen next to the microwave with the Xfinity bill, and the Trooper Tasker said that at least 5 pieces of mail were in the bedroom in a box, which is the same bedroom where the black and white jacket was seen. And with the exhibits 1, 2, and 3 that are allowed in the preliminary exam to be entered, I do believe people who met its burden of proof, which is probable cause, and I am very aware and I understand where you were going with this, and that will be addressed in third circuit. Since you're out of custody, Mr. Jenkins, it will be 2 weeks from today for your arraignment on information. It will be April 5th at 9:00 a.m. Framework College. Anything else for the record?
Okay.
Okay.
Thank you. Sorry for the.
Okay, we are on the record. This is case 2355144, the people of the state of Michigan versus DeAndre Lamar Wilson II, who was charged with count 1, larceny in the building, count 2, stolen property, receiving and concealing $1,000 or more, but less than $20,000, set for a hearing today. Appearances?
Good morning. Yes, good morning. Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Wilson, who stands behind me.
Mr. Wilson, can you state your full name for the record? Good morning to you. Okay, so we set this time and date specifically for Mr. Wilson, who is wishing to plead to a misdemeanor. I have a settlement offer before me, is that correct?
Yes, Your Honor.
I have here that he will be pleading guilty to receiving and concealing stolen property, $200 and less than $1,000. Is that correct?
Yes, Your Honor.
Anything before I get into asking about his rights and why your client?
No, Your Honor, just wanted to put on the record that people do agree to dismiss count 1, the original count 1 and count 2. We have a sentence agreement in place, with terms and conditions to include probation, drug assessment, with treatment and testing as determined necessary by the assessment. Full restitution to complaining witness and no assault of contacting witnesses, and the people have no objection to HIDA in this matter as well.
Mr. Wilson, I'm going to swear you in. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. And make sure you speak up for the court report, okay? All right. So I'm going to ask you a series of questions. If you don't understand my questions, please let me know. If you can't hear me, also let me know, okay? Okay. Is it correct that I see your signature here at the bottom of the settlement offer and the plea form? Is that your signature?
Yes, sir.
Did you go over these rights at the bottom here with your attorney? Okay, I'm still gonna go over them just to make sure on the record that you understand your rights, okay? Make sure you speak up. I have to have acknowledgement on the record, okay? All right. So if you're please accepted today, do you understand that the following rights, you will not have the following rights? I'm going to go through each one. One, that you will not have a trial of any kind. You understand that? Also, that you give up your right to have witnesses called in your defense at trial. And that you give up your right to cross-examine prosecution witnesses at trial. That you give up your right to testify or to remain silent at trial without any inference drawn from silence. That you give up your presumption of innocence and requirement that guilt be proved beyond a reasonable doubt, which is the standard in a criminal trial. Do you understand that? Okay. I have your signature down here, and you stated that your attorney spoke to you about these rights. I find that your rights have been informed, you've been informed by your rights, and that you understand the way of those rights. I'm not going to have prosecutor, I believe. What year is that correct?
I'll allow the
Or
defense.
attorney Miller, I'm not sure.
All right, Mr. Wilson, back in January 10th of this year, did you remove some property from an Orange Lawn address?
You gotta speak up, Mr. Wilson.
No, sir.
You didn't try and sell some items at a gas station?
That's the right address.
Where, I apologize, what address did you remove the items from?
20846.
Okay, from the Fleming address.
I know you can talk louder than.
I'm sorry, I'm gonna see.
Okay.
Okay, oh, sorry, the 20486 Fleming Apartment 105, is that the address you removed items from?
Yes, sir.
And did you take those items and then try and sell them at the BP gas station?
Yes, sir.
Your Honor, I believe that's the necessary, you didn't have the permission to sell those items, did you?
No, sir.
I believe that's factual basis for the charge, Your Honor.
People satisfied?
Yes, people are satisfied.
Okay, so we've been satisfied. I find your plea to be understanding and voluntary, and I will accept the plea as well. And when it works, Mr. Wilson, I won't be conducting your sentence. It will be Judge Bryant. She is also a judge here, handles the misdemeanor sentences. We are waiting still for your sentencing date. I can't schedule that. I would like to put that on the record, but I don't have it. So once you receive a call from the court, I will let both parties know
Yes, Your Honor, and if I may, just one additional thing I'd like to place on the record. Sure. Mr. Wilson, are you a United States citizen?
Yes, sir.
Thank you, Your Honor.
Okay, so we're off the record. Once I have a date, if you don't want to wait, Attorney Miller, I can have that court call you.
Thank you, Your Honor.
Sure.